all very welcome to this Law Society Practice Support Information Session. Where are my clients' title deeds? So how best to advise your client? And I'm joined today by Suzanne Bainton, who's a member of the Conveyancing Committee. You're very welcome, Suzanne. Thanks for taking the time out. And we're short enough on time, so we'll get started.
Yeah, thanks, Justin. I'm just going to talk to you for approximately 20 minutes in terms of basically lost title deeds and what to do if the title deeds are lost, and then we'll leave about 10 minutes hopefully at the end. I'll stay on track in terms of time, because no doubt the half an hour will fly by if there's any questions, or if anybody wants to come in and discuss any of the issues that I've touched on. So I was asked to talk about, where are my clients' title deeds in terms of, if they're lost, what do we do as practitioners to assist our clients? So the first thing, as I'm sure all of you will know, I don't need to stating the obvious, that we should request the deeds early in a conveyancing transaction. One of the things very much on the radar of the Conveyancing Committee at the moment is the seller's pack, the seller's pack bill that is being it's in, I'm not sure what stage the legislation is at, but there's certainly a perception out there, and we all know ourselves what causes delays in conveyancing transactions, but there's a perception that it's a slow process, and when it goes to legals, everything slows down, and the solicitors, to be quite honest with you, are sometimes in the firing line in terms of that. So people are looking at how to speed up the process. So in terms of requesting the deeds, they should be requested early. And under the certified title system, the lender is supposed to give you the deeds within 10 working days of request. As we all know, that often happens, that time limit is often not adhered to. But there is a procedure whereby you can contact the bank and invoke, a complaints procedure if the bank doesn't comply with the time limit. It is advisable to use the QED form. That's the form. It did come out a number of years ago. It was 2010. But the idea is that it's a quick and uniform way of requesting the deeds. And certainly if you use that, you're using it under the certified title system. So the bank should respond within the required time period, not even respond, give you the deeds within the required time period. And it is important to get your client to confirm the correct identity of the lender, as I'm sure a number of you will have come across in practice. A lot of the loans that clients have had, mortgages that they have been sold or transferred to another lender, and they might tell you, I had one recently, they told me it was with Permanent TSB, wrote off to Permanent TSB, no sign of the deeds from Permanent TSB. Oh yeah, by the way, we got a letter saying it's been transferred to Mars or whoever it was, and you're starting the whole process off again. So the lender, the account number, if you sent in the letter with without the account number, they won't, you'd be lucky to get a response, and also the property. So we can help ourselves in terms of making sure we have all the correct information at an early stage in terms of requesting the deeds. If then the deeds don't turn up, the bank have lost them, or if the client had them at home, and we'd all have stories to tell about the deeds that were, they're definitely somewhere but we can't find them, or they were in a box and they were in a box in the garage and we think they got moved out at some stage in a move. So what do you do? If it's a land registry title, it's fairly straightforward, because you can get the folio and map from the land registry. Where we can run into difficulty is where you need a copy instrument. So if there's a lease on title, or if there's a burden on the title whereby there's covenants or easements that affect the title, or there's a fee farm grant and you can't get a copy of that, you can of course request the certified copy instrument from the land registry, but I have had instances myself where the land registry have written back to me to say they can't find the instrument, and despite searching for it, and they're going to keep looking for it. Now I sometimes wonder, are they going to keep looking for it? But you do come across circumstances where you can't get copies of all of the instruments that are registered as burdens on the title. And if that happens, then you're really down to asking your client, is there a neighbour you know, or look on the property price register and see, did any of the properties in the area transact recently, or the auctioneer, if your client is trying to sell, might know of a property that sold. And colleagues are helpful. They will, you know, if they acted in a sale or a purchase of a property, then I'm sure, you know, most colleagues, there's no difficulty at all in assisting each other in terms of providing a copy title. I have had to call on colleagues once or twice for that purpose myself. The planning documents, they normally, you can get them from your law searchers. It can cost obviously a fair amount of money to get copies of the planning permissions. You might have to do the planning search to find out what planning applications the property, then ask the law searchers to get copies of the planning documents. And if your client is very organised, or for any reason there's a copy of the opinion on compliance with, you know, if you bought the property and you perhaps retained a copy of it, if you have a copy, in most circumstances, I think a copy would suffice if it's explained why the original is not available. If the original is not available, the first port of call is to go to the architect who did the original opinion and see if he or she can replicate it. And then if that's not possible, then you're getting excuse me, an architect, engineer, or appropriately qualified person to go out and give a new opinion on compliance. But it's probably in most cases not going to be as good as the first one, because they're doing they weren't involved in drawing up the plans, and they weren't involved in overseeing the construction, insofar as that may have happened in the first instance. In any event, where we do run into difficulties is with registry of deeds titles. That's more complex in terms of reconstituting the title. And, you know, I had a client recently, he couldn't believe that I just couldn't, you know, look it up on the computer, you know, and get the document in terms of the lost deed. And I had to explain to him that the registry of deeds doesn't keep copies of the deeds. It records the existence of a deed, and it doesn't register maps. So all you can get from the land registry is an attested copy memorial, which I know I'm stating the obvious to the audience here today, an official record of the fact that the deed, you know, I was going to say took effect, was put in place. You know, there was a conveyance on such and such a day from Tom to Suzanne of 4, you know, Old Street. That's what it'll tell you, but it won't give you the content of the deed. So what you do in those circumstances is, and I will talk about lost title bonds and first registrations, but in any circumstance where the deeds are lost, you're going to need a lost deed affidavit. I've put the word affidavit in bold because the land registry won't accept declarations. Everything has to be on affidavit. So don't go to the trouble of doing a declaration and then being told, oh, it has to be an affidavit. The contents of the affidavit, and there is a PRAI, I don't know whether it's a practice note or a legal, sorry, there's two names of their guidance notes, but it's on the land registry website, and it sets out, it refers to the case of Gardner and Gardner, which was a case where the court said you didn't have to apply to the court if a deed was lost, that you could rely on an affidavit saying certain things, saying that the original was duly executed, that the parties acted according to the tenor of the deed, and then that it has been lost or destroyed. And good practice would be to also include in that affidavit details of the searches made for the deeds, to exhibit any memorials that have been obtained, to confirm that the deed or deeds haven't been pledged as security, and that if found, they will be delivered to whoever you're making the benefit of the affidavit for. And under that note that's in the land registry, stamp duty must be paid on the copy unless you can show that stamp duty was paid on the original. So there's a few different ways. Obviously, if it was registered in the registry of deeds, it would only have been registered if the stamp duty had been paid, or there may be some other records showing evidence of the fact that the duty was paid. in every registry of deeds case now, so when you're acting for somebody this is typically you're acting for somebody selling a property and the deeds are lost and you're reconstituting the title for them because, again, typically they're selling, and your buyer is going to have to do an application for first registration. So there is, again, a guidance note on the Land Registry website under the heading of first registration and other examiner type cases. So it's a legal guidance note that deals with first registration, but within it there's a reference to what you do when deeds are lost. Now, sometimes you're missing a deed, sometimes you're missing all of the deeds, but there is guidance there, and it's in italics because I'm quoting from that guidance note. And what the Land Registry say is that it's in the context of a longer note where it says you have to lodge the originals, but where the originals aren't forthcoming, you have to give a satisfactory explanation from the solicitor that they were destroyed in a fire, burglary, robbery, or sometimes, they were lost in the offices of the solicitor in a move or something like that. The examiner has to be satisfied that exhaustive searches, so that's what that would be referred to in the affidavit, that copies of the memorials are produced together with a full copy of the missing deed if available. Now, I thought this was, strange. I've seen it before, but the examiner should consider serving notice on the bank's standing committee. I had to look up what that was. I think it's an Oireachtas committee, so I'm not sure the examiners do that, but an advertisement, or maybe it's a committee within the Land Registry, I have to admit ignorance in relation to that. An advertisement in the newspaper, not generally required, must ensure, this is saying the examiner must ensure that there's an indemnity from the applicant. So in any case where you're lodging title in the Land Registry and you're relying on copy title, and even if you have the copies and a lost deed affidavit, if the Land Registry proceed to registration, they will, and even if there is a title bond, they will require an indemnity from the applicant, because as we all know, a Land Registry title is state guaranteed. So the Land Registry is saying, if I'm going to guarantee your title, I want an indemnity from you, that if there's a claim against this title, that I have an indemnity from you, the applicant. So the indemnity has to indemnify both the Land Registry and the state against all loss that may be incurred by virtue of registering the title as absolute, free from encumbrances, without production of the original deed, and if possible from the person who lost it. So if you're in the unfortunate position that you're the solicitor that lost the deeds, you will have to give the indemnity to the Land Registry as well, and the undertaking to produce it if it ever comes into the possession of the person giving the indemnity. And if there is an indemnity bond, the Land Registry guidance to their examiners is that should be assigned to the Land Registry, and if there is a bond available, consider having same issued in the name of the Land Registry in the amount of the current market value for whatever period over 12 years that is on offer. So that kind of gives a bit of guidance as to how much the bond should be for and how long it should be for. So you will get registered in the Land Registry even if you don't have the deeds, but they are the Land Registry requirements in terms of the affidavit that has to be given, and then this guidance for first registration. So do you need a lost title bond? There's three kind of elements. If the deeds are lost, that your first thing to do is to apply for the attested copy memorials in order to put together the chain of the title and to prove that these deeds, were executed, did exist. Then you look at your lost deeds affidavit, because in a registry deeds case, you're going to have to, you're often in a situation that somebody's going to have to make an application for first registration. So the affidavit has to cover off all those things I just spoke about in terms of the requirements of the Land Registry. And then the third thing to consider is, do you need a lost title bond? Now, I have to say, in any circumstance where I've acted, and you don't come across them every day of the week, where I've acted and the original deeds are not available, I have given a lost title bond, or I have been given a lost title bond by the vendor. There is a practice note going back to 1997 that the Conveyancing Committee issued on this point. It is to be updated, so there is an updated one coming down the tracks. It should be out soon. There's nothing dramatically new or anything. That the practice note that's going to come out will refer to that guidance that I've just spoken about there about first registrations, because compulsory registrations in a lot of counties came in since 1997. So the in that practice note, in answering the question as whether you need a lost title bond, it depends on which deeds are lost. So if you're missing one assent or you're missing one deed of assignment, that on its own, if somebody rocked up to a bank, they're not going to get a mortgage based on lodging a deed of assignment. So you need to consider, is what has been lost sufficient to create a charge or lien on the title? And if it's not, then perhaps I don't need a bond. And then a declaration, that the practice note talks about declarations. To be honest with you, the lost deed document, the document that's sworn setting out the circumstances in which the deeds were lost, it's always going to be an affidavit, because it's always going to be going into the land registry for first registration. So it's an affidavit, and the content of the affidavit will be the guidance is from the land registry that I just spoke about. The practice note talks about that if the document has been lost in the solicitor's office, that a bond should not be necessary. Now, again, if you're selling, and again, if the buyer is going for first registration, I think in practice, the buyer's solicitor is going to look for a bond, because ultimately the buyer is going to have to give an indemnity to the land registry, the indemnity that I spoke about earlier. So the buyer isn't going to want to give an indemnity if they don't have the security of a bond behind that indemnity. So if somebody comes along in the future and says, oh, I had a claim on that land, I have an interest in it, makes a claim, the person who has bought on foot of the copy deeds, they've given the indemnity to the land registry, so they'll want to have an insurance bond behind them to cover any costs incurred. You need to consider the amount, and this is all in this 1997 practice note, the amount and term of the bond. So how much should the bond be for? The practice note talks about the fact if it's a remortgage and the deeds are lost and you're doing a mortgage for the client, that it should be for at least the amount of the mortgage. If the property is being sold, the starting point is obviously the market value, and then you need to consider property inflation. Most of the products available, or all the ones I've seen, will have a percentage for, inflation built into them, and you can tick which option you want. The term of the bond, as per the land registry guidance note there, it should be for at least 12 years. So it depends on the circumstances. Time does fix a lot of issues, and once the title has been registered, in the land registry for upwards of 12 years, then anyone should be statute barred against bringing a claim. So that's the idea of the 12, the reference to the 12 years. The bond should cover successors in title and mortgagees. So if you're acting for somebody who's buying, the title deeds are lost, and that is a circumstance where you would have to give a qualification on title to the bank. But if you can confirm to the bank that a lost title bond is being provided and that it's binding on, that it covers, mortgagees, well, that should satisfy a bank. I have it once where we've had lost title deeds and the bank have accepted a qualification. And does the bond cover title to Éireann, or can it be assigned to it? It's not always automatically part of the policy that the land registry, or title to Éireann as they're now called, will be covered by the policy, and they don't necessarily have to be covered by the policy, but it is a consideration, because the land registry ultimately will rely on the indemnity of the applicant, and if there is an insurance bond, well and good. I wanted to mention two practice notes that were issued by the Law Society that are somewhat relevant, not to a circumstance where the deeds are actually lost and can't be found, but where the loan has transferred and you're dealing with a different lender. And as you'll all know, the KBC transferred a lot of their loans to Bank of Ireland, and Ulster Bank transferred a lot of their loans to Permanent TSB when they exited the Irish market. So there were issues for conveyancers. The main issues were, one, getting the deeds in the first place, and that was the issue I touched on earlier. Make sure you find out from your client who is their current lender. Did they get a new account number? You know, do they have an address for the new lender, especially if it's an asset servicing company and not a mainstream lender? And then who do we deliver the deeds to if we have an outstanding undertaking, and where do we get a discharge from? So in relation to the KBC, or sorry, the first practice note deals with Permanent TSB, and that was an issue a lot of practitioners were having, because the deeds had transferred to Permanent TSB from Ulster Bank, but the charge on the land registry folio was still registered to Ulster Bank. So there was an interim arrangement reached, whereby a redacted copy of the transfer deed and a form of discharge would be provided, and they could be lodged in the land registry, and the charge would be removed from the folio. And the second practice note, KBC, that was to deal with who do you give the deeds to when you're on an undertaking to KBC, and the answer to that is you give them to Bank of Ireland if the loan has transferred. And the practice note talks about our obligations under the certain title system are owed to Permanent TSB, sorry, to Bank of Ireland in this case, and it gives the address to which the deeds should be sent. So it is something just to be alert to if there has been a change in lender. Who do you get the deeds from? Who do you get the redemption figures from? Who do you get a discharge from? And who do you deliver your deeds to if you're on an undertaking? So there are those two practice notes that may be of assistance if you came across those circumstances. So I've gone 2 minutes over my I don't know if anybody has there's some questions in the chat, thank goodness. Justin, is there? No.
Well, I don't see any questions there, but we will take them. Here, I have a few questions. So let's start with an easy one. What are the sort of early warning signs that a deed is lost, or is there any sort of, like, how do you get a feeling that
Yeah, I suppose if there's no mortgage, you'll find out fairly quickly, you know, because you'll ask the client where the deeds are, and if they're in front of you, you'll get a fairly blank expression on the face, you know. I always actually, and it's you know, when somebody's doing a will, I ask them where are their title deeds, and I say I don't want your deeds, you know, but I just want to know where they are so that I can make a note, because often when somebody has died, and you ask the family where are the title deeds, and they don't know, and often at that stage it's an elderly person, so there's no mortgage. So sometimes it is, though, Justin, only when you write into the bank and they and you don't get a response, and you follow up then, and it can be very frustrating because the bank will be very slow to acknowledge. Well, they might acknowledge that they're having trouble locating the deeds, but they might be slower to admit that they cannot be found, and that they because then you're going to say that you're going to say to them, well, that's fine, here's my, you know, these are the costs the client's going to incur for reconstituting the title, and can you confirm you're going to cover the costs? I only had one case actually where the deeds were lost by the bank, and they covered. We'd one case where they were lost. We'd another case they were held in the branch in safekeeping, and there was a flood, and the deeds had to be reconstituted because they were so badly damaged. But we had, a non-response from the bank is probably the short answer to your question.
Here's another one. If the mortgage has been paid off, do the bank always return title deeds to the customers directly?
Yeah, the banks, I would love if all the banks had the same procedures, and they don't. I had one only this morning that I was asking my secretary to phone. The mortgage is paid off. I've written about 3 times to the bank, to the central security section. My secretary phoned this morning and she was told, oh, those deeds are held with the branch in Capel Street, phone Patricia, but they don't tend to. Some of the banks will write to the borrower and say, your deeds are available. Do you want us to send them to you, or do you want us to send them to your solicitor? And some of them will do absolutely nothing, and it's up to the client then to, get onto the bank and instruct them as to where they're to be sent. It can take some time, actually, because I remember somebody in the bank saying to me, the releasing the deeds on final release takes longer because they have to triple check that the mortgage has been paid off, just in case there might be any monies outstanding. They won't give you the deeds until they're absolutely sure there's nothing due.
So if a fee farm grant cannot be located and the client needs to review the relevant covenants and conditions in the fee farm grant, what can be done? I'm not too sure that's
yeah, that can come up, because even in some housing estates, the title, there can be a fee farm grant on the, very old fee farm grant. And so those instruments tend not, it mightn't even be registered as an instrument, as a burden, might just say held under fee farm grant, dated on the front of the folio. Excuse me.
Yeah.
One option is the neighbours or other solicitors who've acted in relation to transactions in the same development or properties with the same title. I have had circumstances, though, where we have got bonds from insurance companies, and it's not a lost title bond. It's a bond to insure the owner of the property against any loss that might be incurred because somebody claims on foot of the covenants and you don't know what the covenants are. And they tend not to, they're not expensive policies, so that'd be the ultimate answer, to get a defective title bond if you couldn't get a copy of the fee farm grant.
Susanna, I know we're coming up to 1:30, but we've about 3 more minutes. Here's one about QEDs, and at what point does the 10 days start to run? Solicitors complaining it takes a long time to take up title deeds. And can you explain the benefits of using the QED system, the protections it affords, please?
Yeah, well, the QEDs, the protections of using it is that you're very much within the sort of title system. So you're using that agreed system with the because there's 2 elements of the system. There's one where you're giving the undertaking and you're giving the sort of title. There's the other end of it where you're taking up the deeds and you're requesting redemption figures. So if you use the QED form, you're very much within the sort of title system and the agreed time limits there. The 10 days runs from when you request the deeds, or the receipt of the request from the bank. Now, I was only at a meeting with BPFI earlier this week, and Bank of Ireland start their 10-day running from when you pay the €63, which strictly speaking is not within that sort of title, procedure. And whatever about the main lending banks, if you're dealing with the credit servicing firms, the 10 days just it's an issue of which the conveyancing committee is very much aware and is working with the banks, and has had separate engagement with Pepper in relation to trying to improve the service, for want of a better word, in terms of the timeframes.
Yeah, and just a little bit on the conveyancing committee there is Deborah Leonard, who is secretary to the conveyancing committee, and she can bring forward queries that you may have or try and resolve them if you send them to her.
Oh, absolutely. And we do have a forum with the BPFI. Now, they don't represent, they would represent the lenders and not maybe all of the asset servicing firms. But if we don't know about it as the conveyancing committee, and as you say, Justin, if solicitors let Debbie know, it's not ignored. It is. We don't often get we rarely get an immediate outcome, but if we're not aware of it, we can't address it with the banks. But there is a forum, to raise it with the banks.
Very good. So, unless you have some concluding remarks, maybe just give a few final comments. Next week we've got applying for a PII with Finbar Jeffers. Sorry, it's not next week. It's the 1st of November. We've 2 sessions on PII is on the calendar now. And then on the 15th of November, protection of the client accounts and conveyancing AML with Martin Lawler. So I'd just like to say thanks to Suzanne, unless you want to make some final thoughts.
No, just to thanks for having me, Justin, and I hope there was those.
Listen, there's a last one there from John Griffin, having an issue in ascertaining if life assurance has been paid off. Mortgage was transferred from UB to AIB.
Oh, right. If the life assurance was paid off, is that the words?
Yes, that's what it's saying. Yeah.
Yeah.
Maybe that's one we need to come back to. Yeah.
Yeah, haven't come across that. I have.
Okay.
No, sorry, Justin. Yeah.
No problem. Listen, that was a really informative, and I know it's a very short period of time. Thanks very much for bringing all your knowledge and sharing with us today.